Ok, buongiorno. Credo che già ci siamo tutti, vero?
Mi sembra di sì.
Ok. So I think we can start this session today. Welcome. Good morning to everybody. It's really a pleasure for me to be here. Um, we are starting today with this session, panel 3, on the institutional arrangement which can protect liberal democracy. We have 9 participants, so I know that you all know the rules of this panel. You have 10 minutes to present your paper, to give the main hints of your presentation. And then we have a session of question and answer with the public and a little debate. I think that the session that we are working on today fits very well in the program. It has a great coherence with the yesterday session, in which general aspects of constitutional degradation have been analyzed. We all know that we are facing really complicated times all over the world, and the liberal democracies are under pressure. Yesterday, the constitutional degradation in distinct forms has already been analyzed. Today, in this session, we are talking about possible institutional arrangements that can help in the task to protect liberal democracies. I just would like to propose you a little switch in the order of presentation. If you don't mind, I will present first of all Simon Drugda. Simon, are you here?
Yes, I'm here.
Perfect. Thank you so much. Just a few words about Simon. Simon is PhD candidate at the University of Copenhagen in the Center for European and Comparative Legal Studies. Thank you so much, Simon, for being here. You have 10 minutes to present your paper, and the floor is yours.
Thank you very much. I'm happy to be here today, joining you at the event, because I'm on a parental leave currently, so I do not get many opportunities to discuss such interesting topics as we are at this event. Today I'll be presenting on my paper, which is about the idea when should constitutional court judges be appointed. And I would like to start maybe with a disclaimer that despite the fact that I'm writing primarily about constitutional court judges, this could also apply to any other office holders in checking institutions in a democracy, right? So in institutions that are supposed to be controlling the majority and the political powers within a democracy. I write about constitutional court judges because I use as a backdrop or a case study in my paper the delayed appointment of judges of the Constitutional Court in Slovakia in 2019, 2014, and early 2000s. There were 3 episodes of delayed appointments in Slovakia, which is a negative occurrence because ideally, right, the checking institution should be appointed, fully staffed, to be ready to potentially defend the democracy against hostile takeover of the populists or any autocratic tendencies within a state, fleeting majorities, for example. So I examined these delayed episodes of the delayed appointment, and I tried to classify them or create a classification of how we can understand delay, and I devised them in 3 categories. The first one is bad faith strategies. These are strategies that are used by political actors to achieve some goal that is negative for the health of the democracy. It is a strategy. These can be strategies that we do not want to see within democracy. And I use the term emptying the court because that is what usually results out of the delay. And the term emptying is a sort of a phrase that is used by, or term used by, I don't know if you're familiar with the work of David Kostas and Katarina Shipulova, who recently wrote on court packing, and they examined court packing as a sort of umbrella concept and identified different modes of court packing, and emptying one of them. Emptying is unlike what we understand as expanding the court. Emptying the court is a short-term strategy which leads ultimately to vacancies on the Constitutional Court, right? It is a strategy that is perhaps suboptimal because it only gives advantage to the political power in the short term. Because ideally, in the long term, it will be able to appoint the judges that it wants to achieve the influence on the law in the long term, right? But emptying is a short-term strategy. It can be a bad faith strategy, but it can also result out of objective considerations. So the second category that I identify, other than the bad faith strategies, is disagreement, normative disagreement within a polity about who should be the Constitutional Court judge. And this can happen when the parties, for example, are not, or the appointing actors are not quite sure who should be the Constitutional Court judge based on, for example, ideology. It happened in early 2000s in Slovakia when the concern was the religious faith of the candidates, and the appointing actors failed to appoint Constitutional Court judges because they disagreed whether these candidates should be religious or not, and as it would then later kind of play out in cases about abortions. The final category that I identify are sort of factors that can influence and affect delays in the process that are objective, but can be also used as justification for bad faith strategies. So these are both, this can be used both as negative, but also understood as sort of neutral considerations that affect delay. And I identify several of them. The first one is a lack of talent within the jurisdiction. The second one is lack of information about the candidate. The third one is lack of publicity of the process or reputation of the court. The fourth one is lack of processing capacity of the appointing actors. And the fifth one, the last one, is inefficiencies in the design of the selection mechanism. And I will speak shortly about each of the categories. So the first category that can result in a delay in the appointment process for Constitutional Court judges is lack of talent within a jurisdiction. We normally would like to think that there is always enough qualified candidates for the position of the Constitutional Court judge within a jurisdiction, but it doesn't necessarily have to be the case, especially after transition to a democratic regime that is accompanied by lustration of former judicial elites. There might be a shortage of candidates who are qualified for the position, or who have not been flagged by the process as potentially problematic. So as a result, there might be constraints on the population of the judges that can apply for the position on the Constitutional Court, and then we have a delay. The second, excuse me. Yeah, the second issue is a lack of information. A lack of information can play out when or happen when during the process there is some information revealed about a candidate that hasn't been disclosed at the beginning of the process, or it can be some hidden information that has been hidden by the candidate purposefully, or it can be misinformation introduced by the candidate or some of the nominating actors into the process. And what happens then is that the appointing actors might need to backtrack in the process to verify this information and contextualize it within the rest of the application. Just to help you kind of imagine how this could work. For example, in early 2000, there was a Constitutional Court judge in Slovakia who was withheld an expunged conviction for fraud in the appointment process, and later it created a scandal when the appointing actors found out that they actually placed someone on the Constitutional Court who has been convicted for criminal offense. Right, so this kind of information can potentially result in a delay in the process. The third category that I talked about is a lack of reputation or publicity of the process, or reputation of the court or publicity of the process. And reputation is sort of a concept that one of our speakers has also written about before. One of the speakers at the event, the keynote speakers, Tom Ginsberg, he has written a book about judicial reputation, which is the idea that courts can acquire reputation and then sort of use that reputation to acquire secondary benefits or compliance with their decisions. But imagine there's a new court within a jurisdiction that doesn't have yet a name made for itself. It can be, as it was, for example, in Slovakia, that there is not enough applications for the position on the court because the court is unknown, or there's been lack of publicity of the process by the appointing actors. And as such, there's not enough candidates to consider and appoint to the institution. This can again result in delay in the appointment. It kind of manifests in a similar way as a lack of talent, but it is not a result of lack of kind of population of the judges that could apply for the court. Just the judges who know about the process or are attracted to the position. The fourth category is lack of processing capacity of the appointing actors. And this can happen when the appointing actors, for example, do not have enough resources, material resources, staff, or other resources to in time and due time process the applications of the candidates for the position. It happened in Slovakia when suddenly there were 40 applicants for a position, and the selection hearings were delayed, which resulted in kind of a delay in the process overall. The last category that I identify are inefficiencies of the design of the selection mechanism. This can be many different things, but for example, one inefficiency that can result in delayed appointments is limiting the applications to the position to candidates who are nominated for the position instead of open calls. Right, so we'll have less applications because there's a sort of a bottleneck in the nominating actors who need to nominate someone rather than having all the applications being open. Right. What I do in the second step in my paper is I consider anti-deadlock mechanisms. And for those who are familiar with the Venice Commission opinions, Venice Commission often advises that there should be, in the design process, there should be some anti-deadlock mechanism introduced in case there is a delay, there is a deadlock, there is a time in the appointing body that, for example, the threshold for the appointment is lowered. And I argue that anti-deadlock mechanisms, such as lowering the threshold for the vote on the judges, works well for bad faith strategies or even normative disagreement about who should be the judge, because eventually the threshold is lowered just enough so the opposition can potentially influence the outcome, despite the majority that is kind of causing the delay, but doesn't really work well for the other objective criteria that can result in a delay, such as lack of talent. If there is not enough candidates for the position, anti-deadlock mechanisms will not really help us because there's just not enough applications. If there's lack of processing capacity, anti-deadlock mechanisms will again not help us because there's just too much applications for the body to filter through that results in a delay. So I try to then devise some ways how to deal with this third category of criteria that can result in a delay, and that was my time. And I yet need to strengthen that part of the paper where I try to kind of deal with each of these small categories, such as lack of talent, lack of information, lack of publicity, lack of processing capacity, and inefficiencies in the process. So I would be really happy about any feedback on that part from you. Thank you very much for listening to me, and thank you also to the organizers and the chair for allowing me to speak first because I'm sick, and my son is sick as well, asleep, and so I might need to deal with him later. Thank you.
Thank you so much, Simon. I think we had a very great kickoff of this session today. I think that also that your paper is really interesting, and we'll have I think that you are putting on the table very interesting topics that will be discussed in the debate session later. So thank you so much for the effort and for participating. So the next speaker will be Ilenia Citino. Ilenia is PhD in Constitutional Law at the University of Roma III. And she is presenting a paper on comparing constitutional provisions regarding parliamentary opposition, an introductory note. So we are moving from judges to parliament. And Ilenia, thank you so much for participating, and the floor is yours.
Thank you very much. Dear colleagues, I'm very grateful to be involved here today in this prestigious meeting. It's been a very intense debate so far. I would like first to thank the organizers of the workshop, and it seems from the outcome of the present talk that democracy is more and more on shaky grounds. But in my opinion, parliaments are being the major victim of the so-called constitutional degradation. They are in fact being marginalized by multiple factors. The pandemic, for example, and its mismanagement by major democracies is adding fire to the general discontent. But the deterioration of the liberal democratic order is unveiling the dysfunctionalities and the unpreparedness of the representative institutions. It shows that the deliberative process is a hinder from passing laws in a timely manner, as it is required at the present days. Therefore, we can all agree that the opposition, the political opposition, is currently under harassment. This is the reason why today I will make a comparison between the constitutional provisions regarding the parliamentary opposition. And this is just an introductory note, because this topic is very, very dense. However, it remains paramount to lay down a status for the opposition, and this is what I will try to show you today. It's a principle that it was recognized in relevant national resolutions, and it's even more important today when the rise of populism and nationalism worldwide is fostering new cleavages in the society and is spreading illiberal practices within the established political elites. If this phenomenon, let's see, for example, about Brexit, Trump and Bolsonaro's presidency, or Hungary and Poland, or many other states that we've been talking about since yesterday, if these examples are disregarded, they may lead as a last resort to political and constitutional disintegration, which is even more than constitutional degradation. And this may happen also in well-established democracies. So the importance of a widespread understanding of the role of the parliamentary opposition in the legislative and scrutiny processes is key, not only to the consolidation of young regimes, but also to the fight of the erosion of liberal standards in older democracies. Some of them, they are in fact witnessing legendary changes in the political system. All these changes, they reflect the marginalization of the parliaments. So what I saw in my research is that the lack in a performing set of rules to encourage a political competition in a constructive way can affect the quality of the political debate. But my question for you today is, if it's true, the opposite statement, can really the institutionalization of opposition rights preserve the degradation of political debate? As you will see thoroughly in my paper that will come after my speech, making a comparison on the constitutional provision of the status of the opposition is a complex topic that requires a multifaceted methodology. Comparative methodology can be hard sometimes because we have to deal with a huge amount of legal and political data. And I will consider today only the legal institutions. I will not consider, for example, all the vicissitudes of political actors, because these ones are too changeable. So in the present case, I just want to highlight the juridical significance of the phenomenon. I will have explained why not all of the legal sources can be used in this analysis, because we shall converge only on the constitutional provisions. What are the other legal sources regarding opposition? We're talking about the rules of procedures, the standing orders, unwritten rules, conventions, customs of the constitutional binding precedents, or even any other regulation enacting the Constitution. This is also constitutional matter. Try to think about parliamentary immunity, or the laws about public financing of political parties, or rules that contain a supermajority, or all the rules regarding the association of citizens. All of these could make an endless scope of this note, but today I will just focus on the constitutional provisions. And last thing I want to say about my method before drawing to my findings is that I have used a web constitutional platform which is called constitute.org. This is a platform developed by the University of Austin and Chicago that is translating every enforced constitution of independent states in English. So using this platform, I performed 2 queries and looked for the word opposition and the word minority. And of course, I had to remove all the results that were mentioning the racial, ethnical, or regional minorities, because we're talking about political minorities. And therefore, I tried to outline a model, and I made a spreadsheet where I listed all the countries and tried to arrange them and the different groups and connecting them with their electoral system. All of this is very complex, and there's not much time left to further deepen the discussion on the method. So I will refer once again to my written paper and will limit my conclusions to 4 considerations. The first one is the consideration about the absence of a statute of the opposition in civil law European democracies. All of them, or most of them, avoid to address the issue, and it is no surprise that the largest majority of developed democracies does not officially recognize the opposition in the constitution. They don't even mention it. This, however, does not denote a lack of constitutional protection, because we may interpret this absence considering that the values and principles enshrined in the spirit of the legal system, they don't need to be formally mentioned. Some guarantees can be implicitly laid down. All of our constitutions have provisions regarding the supermajority votes or other parliamentary procedural rules at constitutional levels, or even general principles like the freedom of political speech, the right to form political parties, the right to pluralism, and so on. Which are the explicit examples? We can talk about Germany. The Grundgesetz is silent, but most of the Bundesländer constitution, they have what they call the Oppositionsartikel. At the national level, we can have 2 real examples in the 1976 Portuguese Constitution and the French Constitution as amended in 2008. We all know, I hope, the history of Portugal, but regarding France, France has undergone a relevant political transition after the 1962 referendum that introduced, as you all know, I think, direct presidential election. But they felt in years to come the necessity to provide a formal statute to the opposition. This happened just in 2008, where the modernization of the constitution was possible, and they framed not 1 but 2 opposition articles. And finally, there is a small reference in the Swedish system. They talk about minority spokesmen for a committee, but this is just a minor mention. As to Italy, failure to provide a formal statute to the opposition was registered after the unsuccess of the 2016 Renzi-Boschi constitutional reform that tried to amend Article 64 of our constitution. So I really have to summarize about this, because these few examples, they suggest that the above definition of opposition it seems more emphatic than prescriptive, because with these states, we have most of the time grand coalition governments. So if we follow a statement made from Dahl in 1969, so a lot of time ago, the absence of status of the opposition in high consensus European systems creates a sort of Leviathan political elite in which the people do not identify anymore, thus leading to anti-system opposition. This is a very important assumption, and it's regrettably confirmed by the recent empirical evidence. The second consideration is that if we try to design a catalog of definition, there is no global unique definition, and we can really identify a difference between the Commonwealth country, or the countries having a strong British influence as a first past the post electoral system, because they refer to the constitutional position of the leader of the opposition, or they provide a numerical criterion, as it happens with Bhutan. Bhutan is the only full-fledged example of constitution having a definition of opposition in the whole world, and that's very, very interesting. So all the Commonwealth countries, we can extract a definition of leader of opposition by the discipline regarding the leader of the opposition. Well, I do not have the time to discuss about the constitutional patterns regarding the rights of the parliamentary opposition and the duties of the parliamentary opposition. So my last consideration will be about another relevant example, which is the combination of Algeria, Morocco, and Tunisia's constitution. They provide a long catalog of rights, granting under condition of respecting also the parliamentary duty of the parliamentary opposition. So they really ask the opposition to have a proper behavior and be constructive in the political life. And this is very important it's a very instructive example, because these countries, they are Arab countries, and most of them, they have undergone a very important democratic transition after the Arab Spring. What is my conclusion in this paper is that we need an inversion of the constitutional borrowing. Constitutional borrowing is a very important notion, and it's been defined as the tendency to draft a charter by inserting language taken from another people's governing document. However, traditionally, the borrowing was in a one-to-one direction. It started from the most established regime, and it went through the emerging democracies. This time, probably, we have to do the opposite thing. We have to borrow from the emergency democracy that have an explicit statute of the opposition, and try to see if this can fit also in our older democracy, to see if our degradation can be solved by this institutionalization. Thank you very much.
Thank you so much, Ilenia, for this interesting presentation. You gave us a very deep perspective on the role of parliamentary majorities and opposition, of course. And I really appreciate this wide comparative perspective that you gave us, because many research on this topic are generally focused on the European liberal democracies, and they exclude another important part of other constitution from other region of the world. But it's very interesting that you also included African countries. I don't know. I feel that you have not mentioned something about Latin American countries, but maybe in another part, another stage of your research, you should investigate also this part, because they are really interesting, because there is a very huge gap between what the constitutional text says and what is what the constitutional reality is. So it's just a suggestion, but maybe in the discussion of this meeting.
I will talk about Colombia and other countries, but I didn't have enough time to discuss every part of it.
Okay, perfect. So thank you so much, Ilenia.
Thank you.
So we are going through the next speaker. Ilaria De Cesare. Ilaria is a PhD in public law, criminal and international justice at the University of Pavia, and she is presenting a paper on constitutional degradation and the Italian parliament. How can the centrality of the representative body in the Italian legal system be preserved? Thank you so much, Ilenia, for being here, and the floor is yours for 10 minutes.
Thank you so much, and let me thank the committee, the scientific committee, for this wonderful opportunity. I'm very honored to be here today. In my paper, I chose to analyze the constitutional degradation, looking at the exercise of the legislative function in the Italian legal system, an exercise which is not exclusively implemented by the parliament, but it is shared with the government. That's because the Italian legal system is a parliamentarian legal system, and in which the parliament and the government are linked by a vote of confidence. So in my analysis, I will focus on the recent years in a diachronic dimension, and using the time framing that divided our republic life in 3 different moments. And in particular, I will refer to the so-called Third Republic, that is referred to the last more or less 25 years. And my speech, it will be divided into 3 parts. In the first part, I will pose the premises of my analysis about the constitutional degradation and about the form of government, the Italian form of government, looking at the exercise of the legislative function. In the second part, I will analyze some institutional behaviors that seem to be signs of this constitutional degradation. And finally, I will propose some solutions to this degradation. And first of all, we need to define the meaning of constitutional degradation, because this idea seems to be linked with a sort of transformation of the legal system. And if a transformation in the equilibria concerning the functions assigned to the institutional bodies can occur in every legal system, it's a normal phenomenon of a legal system, we must understand which kind of transformation we are talking about. In other words, I think it is necessary to understand whether we are observing a reassessment of behavior, which is in line with the constitutional starting moment, or we are observing a different kind of change that is transform our legal system. And in my opinion, the constitutional degradation, of course, is a degeneration, a negative change that is occurring in our legal system that probably started as a readjustment in the equilibrium between powers, but is actually becoming a real transformation of the legal system. So we must investigate what are the institutional behavior in the exercise of the legislative function in order to verify if they are in line with the Constitution. The risk of the constitutional degradation is that it can lead to a structural change of our legal system without a formal revision of our written constitution. And this can lead to a break into constitutional bonds. Moreover, the same concept of form of government is not merely a descriptive notion, rather is prescriptive. And as also said our Constitutional Court, starting from the decision number 7 in 1996. So the institutional behaviors of public bodies must always respect what is the perimeter laid down by the Constitution. Some words about this perimeter, I think, are necessary. As just said before, the Italian legal system is a parliamentarian one in which the parliament and the government are linked by this vote of confidence. Consequently, the exercise of the legislative function is not exclusively of the parliament. The government takes place in the exercise of the legislative function through many instruments given by the Constitution, through, for example, the legislative initiative, through the possibility to adopt decree laws in extraordinary cases of necessity and urgency, and by issuing decrees after a delegation law by the Parliament. However, the exercise of the legislative function is owned by the Parliament, as we can get from Article 70 of the Constitution. So, even if there is a condivision, the exercise of the legislative function is shared, the ownership belongs to the Parliament. And for this reason, the Parliament needs to have a prominent role in the lawmaking process. And this role can either expand or decrease, but it never disappears. All that is because the ownership of the legislative function is linked with another element of our legal system. The Chamber of Deputies and the Senate are together the expression of the representative principle, of the national representative principle. In fact, through the legislative function, the elected majority can translate its political program into laws, considering the instances coming from society. Even if this is the constitutional draft, actually the Parliament doesn't seem to be as prominent as in the past. In fact, in the use of governmental instruments of co-participation in the legislative function, we are observing some practices that can be regarded as signs of this constitutional degradation, because they are signs of this loss of prominence of the Parliament. Most of all, we can underline the following three. The first one is the massive use of decree laws by the government in absence of conditions imposed by Article 77 of the Constitution. Today, decree laws appear to have replaced the legislative initiative by the government. The second one is the way in which the Parliament delegates the exercise of the legislative function to the government. Very often, we are assisting to a phenomenon defined law with delegation. It's when the delegation is inserted in a different law, for example, in a confirmation law of a delegation law, of a decree law, sorry. And the first sign of the loss of the prominence is the praxis to impose the vote of confidence on maxi amendments, an instrument that we can say frees the content of the law and excludes the possibility of a parliamentarian discussion. All these practices that which today appear to be usual practices are only instruments used by the government to impose some choices concerning normative acts. This praxis limit the parliamentarian discussion, each in its own way. And during even during this period of pandemic emergency, the prominence of the government in decisional processes was very, very clear. We must underline that if a prevalence of the government in emergency context can be in line with the Constitution, think another time to Article 77 of the Italian Constitution, we should not forget that initially in Italy, the Parliament was almost totally excluded from decisional processes. And this situation was partially recovered only at a second stage, after the adoption of Law Decree number 9, 2020. It is clear that the reduction of the Chamber's prominence in the exercise of the legislative function is affecting the ownership. And that's why we must think about some solution to limit this praxis. In fact, it is the erosion of the ownership of the legislative function that can cause breaks into constitutional bonds, because it can lead to a structural change without this formal revision of our Constitution that is imposed by Articles 138 and 159 of the Italian Constitution. So, among the many possible solutions, I think a reform of the parliamentarian rules seems to be the most adequate in this moment. This reform should introduce procedures to limit the practice described before in order to guarantee the respect of constitutional draft about the exercise and the ownership of the legislative function. And maybe we can imagine the legislative process in this reform as a genus that includes two different species. A political one in line with the constitution, so in which the parliament is the protagonist, but also a sort of a technical procedure in which we can have a prominence of the government, of course, without excluding the parliament, because it's the owner of the legislative function, depending on the type of matters or decisions that have to be discussed. This may be a solution that on one side will respect the constitutional legal system, but at the same time, it will take into account the new instances coming from society and requiring a new, faster and technical decisional procedure. And in this way, I think the constitutional degradation may be prevented from becoming a constitutional break, and may even turn out to be useful for an evolution of the Italian legal system. Thank you.
Thank you so much, Ilaria, for this presentation, for this focus on the Italian Parliament, and for suggesting some possible solution to some of the contemporary problems that our Parliament is facing. I also would like to take the chance to welcome Professor Giorgio Grasso, who is following us. Thank you, Giorgio, for being here. Also, Professor Valentina Rita Scotti, I see her connected, and also Andrea Gatti. Thank you so much for joining us. We are going now for the fourth presentation. Now it's the Marco Bruno Fornaciari turn. Marco is lawyer at the Taranto Bar Association, and he is presenting a paper on the evolution of the constitutional order and the role of the High Courts, a comparative perspective. So now with the Marco paper, we are coming back to the judicial power perspective. Thank you, Marco, and the floor is yours for 10 minutes.
Buongiorno, ringrazio vivamente l'Università di Siena, DISAG, Dipartimento di Studi Aziendali Giuridici, e DIPEC, Gruppo di Ricerca e Formazione su Diritto Pubblico Europeo Comparato, per la possibilità altamente qualificata di ricerca scientifica. L'obiettivo del presente contributo è compiere qualche riflessione sul fenomeno delle cosiddette regressioni, ovvero degenerazioni costituzionali, basandosi sull'analisi di alcune esperienze fondamentali che assurgono a caso paradigmatico. Si pensi alla Polonia, all'Ungheria, alla Federazione Russa, alla Turchia e al Venezuela, e analizzando il ruolo e le sorti delle corti apicali sia nella fase della regressione che in quella successiva. In particolare si intende esaminare le modalità in cui le regressioni hanno inciso sul testo costituzionale. Le riflessioni che scaturiscono dall'indagine comparata delle 5 esperienze citate evidenziano un fenomeno di ampia diffusione pratica e di altrettanto attenzione da parte della dottrina internazionale, che è molto concentrata sul tema del decadimento delle democrazie, sullo sfondo delle crisi che, prendendo di mira proprio il potere giudiziario, hanno indotto in alcuni casi il deterioramento di assetti democratici apparentemente consolidati. Ciò nonostante si evidenziano difficoltà di inquadramento di questi fenomeni, nonché delle forme politiche istituzionali che generano, se si pensa in particolare alla tradizionale classificazione delle forme di Stato nell'ambito degli studi di diritto comparato. Infatti gli assetti ordinamentali dinanzi ai quali ci troviamo rivelano caratteristiche ibride, mescolando elementi autoritari ed altri apparentemente in linea con gli standard delle democrazie occidentali, come dimostra il fatto che gli ordinamenti oggetto di disamina sono parte di organizzazioni sovranazionali che si ispirano ai valori del costituzionalismo liberale, assunti quali criteri per la permanenza e l'accesso appunto ai consessi sovranazionali. Lo studio dei fenomeni di crisi o regressione della democrazia costituzionale è utile onde comprendere le modalità delle degenerazioni, enucleare i tratti salienti e comuni del modello degenerativo e infine onde arginare i rischi di circolazione. Gli aspetti principali su cui soffermare l'attenzione riguardano le modalità delle degenerazioni nei diversi casi esaminati, soprattutto in relazione al testo costituzionale, ovvero viene modificato, svuotato, interpretato, ad hoc o addirittura sostituito. Riguarda ancora il ruolo delle corti apicali assunto nel percorso degenerativo, ovvero sono state passive, conniventi, ovvero ancora ambigue, e nel consolidamento o stabilizzazione del nuovo assetto. Infine si presta attenzione alla responsabilità della dimensione sovranazionale con riferimento precipuo al Consiglio d'Europa, all'Unione Europea e all'Organizzazione degli Stati Americani, unitamente alle relative corti apicali. Gli ordinamenti presi in considerazione, pur ascrivibili a contesti culturali e geopolitici parzialmente differenti, sono stati tutti interessati negli ultimi lustri da un decadimento, ovvero da una regressione costituzionale, sia laddove si era raggiunta una stabilizzazione democratica che nei sistemi politici che recano una cifra geneticamente autoritaria. Nonostante il frequente ricorso a definizioni quali democrazie liberali o regimi populisti, sui quali ci siamo soffermati anche nella giornata di studi di ieri, il 21 giugno, è preferibile parlare di regressione, ovvero involuzione costituzionale, indicando una modifica, ovvero un emendamento e una sostituzione della Costituzione, ovvero ancora l'esautoramento o la deroga alla Costituzione, al fine di neutralizzare il sistema di checks and balances da essa previsto. Le corti apicali sono state inevitabilmente coinvolte nella degenerazione autoritaria e nel successivo mantenimento dello status quo, venendo a seconda dei casi assediate, conquistate, ovvero ancora neutralizzate oppure manipolate per consentire ulteriori trasformazioni di sistema. Il coinvolgimento delle corti apicali nel percorso degenerativo dipende da diversi fattori, riconducibili alle pressioni della maggioranza politica dominante in un dato momento storico, ma anche agli errori dei legislatori precedenti o dei costituenti, come nel caso ungherese e polacco. Influiscono su tale percorso le modalità di selezione dei giudici e la possibilità della loro rielezione, nonché riforme che, per giustificare la sostituzione dei giudici delle altre corti interne, si riferiscono a loro presunte inefficienze, a fenomeni di corruttela, ovvero compromissione col passato regime, oppure procedono ad un pensionamento anticipato ope legis, come è avvenuto appunto nei casi paradigmatici della Polonia in relazione ai giudici della Corte Suprema. Tuttavia, anche i giudici politicamente nominati o lealisti potrebbero dimostrarsi non del tutto allineati, come trapela qualche opinione dissenziente. Vi è poi la naturale questione della naturale deferenza dei giudici costituzionali verso il potere esecutivo e in special modo verso il capo dello Stato, come si può apprezzare appunto nelle esperienze ordinamentali della Federazione Russa e della Turchia. In alcuni dei casi oggetto di disamina, corti che in passato avevano dimostrato un protagonismo spesso rivolto contro le maggioranze al governo, hanno invero visto ridurre drasticamente il proprio ruolo, sia attraverso cosiddette infornate dei lealisti, che con la riduzione costituzionale delle prerogative, come è avvenuto appunto in Ungheria e in Turchia. Si può quindi distinguere tra ordinamenti in cui il potere politico ha avuto un atteggiamento punitivo nei confronti delle corti apicali, come si può apprezzare appunto negli ordinamenti ungherese, polacco o turco, e altri ordinamenti in cui il potere, concentrato prevalentemente in capo al Presidente della Repubblica, ha cercato di soggiogare tali corti a prescindere dal loro comportamento, come è avvenuto appunto nell'ordinamento della Federazione Russa e in Venezuela. Grazie e una lieta prosecuzione di lavori.
Thank you so much, Marco Bruno Fornaciari, for this very clear presentation on the role of high courts. I think that we are going to have a very rich debate with all these suggestions that are emerging from your presentation. So now we are going to the fifth presentation of this session. It will be presented by Mayra Angelica Rodriguez Avalos. Mayra is a PhD student in comparative law and processes of integration at the University of Campania Luigi Vanvitelli, and she is presenting a paper on the title "In Defense of the Constitution, Judicial Autonomy and the Crusade of Judiciary in Mexico." I'm pretty sure that it's going to be a very interesting paper, also because now in Mexico there is a very complicated debate on the judicial autonomy, and well, Mayra is going to explain us this situation. Thank you so much, Mayra. The floor is yours.
Thank you, Professor Irene Espino, for the introduction. My apologies for my pronunciation. It's not good in English, but I try to do better. My central thesis is that a form of the constitutional degradation is the attacks and interference of the president of the nation on the judiciary, because it weakens the rule of law institution. My presentation I have divided in three parts. First, I will speak the importance of the Constitution and the rule of law, as well as the integration of the Mexican state. In the second, I will speak about the importance of the judiciary for the protection of the Constitution and the rule of law, concentrating on the point of the tension between the head of the executive branch and the judges. Finally, I will present my partial conclusion, because this issue is concurrent and continues to occur until today. One, Constitution and rule of law. The Constitution is a container of the ideas which protects the public power and its distribution, the human rights, the inclusion and operation of the mechanisms of the control of the public power exercised by the institutions that are born of the states. As Roberto Sartori says, therefore they are the instruments of the government that limit, restrain, and allow the control of the exercise of the political power. Six essential features are in the Constitution: self-protection, abstract content, incorporation of the stony clauses, protection of the mechanism to ensure the preservation of their sense, organization of the function of the state, and the creator of the legal system. Similar, the rule of law is defined as the framework that allows the balance between the notion state apparatus, state community. It is then an institutional design, as Marcus Ravagos pointed out, that provides legal certainty. According to Norval Lawson, the separation of the powers is a mechanism of their safeguarding in which each has attributed a certain functional nucleus in which third parts intrusions are not permissible. In the specific case of Mexico, the powers of the Union is divided in three sovereign power independent in their integration and function. The judiciary is vested in the Supreme Court of the Justice of the Nation, as well as in the Electoral Tribunal, collegiate circuit courts, and district judges. There is a regulatory body named the Council of the Judiciary, which monitored the compliance of the members of the judiciary with the Constitution and the law. The legislative branch will reside in the Congress of the Union, with a chamber of senators and a chamber of deputies. The executive branch is confined to a single person, now as the President United of States Mexican. For their part, the outermost constitutional organs are those organs of the states with the legal personality and specific powers to guarantee the balance of powers. They are born out of the Constitution and therefore are not subordinated to the traditional powers, characterized by the competence to exercise to the highest degree a complex of public functions. In Mexican state, there are 8 bodies, including the Federal Commission on Economic Competition, COFECE by acronym in Spanish, which guarantees the free competition and investigated and prevented monopolies and monopolistic practices, in specific in energy matters. Second, the judiciary as the last bastion for the defense of the Constitution. The course of the judges is based on autonomy, as it guarantees the allows them to resolve matters without interference from others, in accordance with the provision of the Constitution and the laws. The judge must and is subject to the law, but in his interpretation, to some extent, he must be independent of imposed criteria and cannot be reduced to an application or interpretation of the laws. The idea of the independence of the judge is inextricably linked to the conception of the constitutional state. It guarantees the separation of powers, which in turn protects the very existence of the states. In Mexico, the concurrent government has aided the alternative project of the nation's vote, which aims to decade the rebirth of the Mexico with a structural reform that leads up the previous neoliberal policies. Among these objectives was the disappearance of the energy reform of the 2015. Its first strategy was the Energy Secretariat Agreement in May 2020, which proposed new roles for energy sector not provided for in the Constitution or energy law. Against this agreement, the Federal Commission on Economic Competition filed a controversial constitutional mechanism of the protection of the Constitution before Supreme Court. The second strategy is the reform of the electric industry law, which concluded contracts for the wind power generation before then reforms. For this reason, we're filing with the judiciary 2 proceedings, juicio de amparo, provided by the Constitution as a mechanism for the safeguarding the human rights. Similarly, COFECE filed a controversia constitucional, in fact, the second controversia constitucional, because laws reform encroachment on its competence refers by the Constitution. Respect for the first controversia constitucional against the first agreement, the Supreme Court guaranteed the suspension of its application. The president therefore began his campaign against the decision of judges. With regard to the reform of the energy law transition, but this time directed its attack directly to the judges, in specific to judges. The opinion of the president in order to the credibility of the judges were directed to the suspect speak to decide on the provision and later definite suspension of the law. However, the Amparo law, a specific law for this process, established as a legal term to decide on its granting in a provisional manner, and therefore the definitive term that begins with the admission of the claim. In fact, as the author Neofito López Ramos refers, the effectiveness of the juicio de amparo and the suspension of the Claimant Act have long-standing wrongs that have proven their merit throughout the legal history of Mexico. And the autonomy and independence of the judges is the essence of the decision that should not be divided, as in case concrete, in the personal appraisals of the holder of another sovereign power, especially that the statements of the president distort to reality. The other problem is centered in the announcement made by the president to present a constitutional reform so that the energy transition law is not considered unconstitutional. Reform already announced for a few days ago as a result of the protection that the judges granted to the legal reform undertaken by the their government. Reform that he announced has, after his meeting with the president of the Supreme Court and other two ministers. However, precisely in the presence of the unresolved procedures of the subject, the president of the Supreme Court attended in the company of two other ministers a meeting on a possible constitutional reform with respect to the challenged law, which implies that their abstention to resolve in the case that arises in the relation to the laws that were the subject of their conversation. This visit degraded the principle of the division of powers and the imperative that the relation that must be established between the powers are only those that the Constitution itself authorizes. So, my partial conclusions: the transformation of the nation must be in accordance with the lines I pressed that the Constitution establishes, because from it are born institutions that follows law. If any of them is altered, no other structure can be rebuilt. There remains a vacuum that leads to uncertainty. The Constitution must include the change resulting from the social structure, but they must follow a dual process that provides legal security and not for hence an improper interpretation of its principles or laws. Following a different path, it is risky. It encourages to make it a recurring one, as has already been happening in Mexico in other areas, such as in the cases of the biometric data law. Another matter of interferences with the judiciary is the extension of the mandate of the president of the court in the interest of the federal executive branch, despite the fact that the Constitution establishes a term for this. Unconstitutionally, in a secondary law was approved in a transitional article, its extension to 6 years. As can be seen, once the line of the division of the sovereign power has been blurred, it increases the frequency with which the head executive branch crosses it against what the Constitution itself orders. Therefore, it is the judges who have in their hands the formal and the material guarantee of the Constitution, are the last line of their defense and of the rule of law. Thank you so much for your attention. Ringrazio a tutti e a tutte per l'attenzione.
Thank you so much, Mayra, for presenting this interesting case. Actually, Mexico now is one of the most interesting cases to be analyzed, especially in the relationship between the executive power and the judicial one, especially for the relationship that these two branches of the government have, and the populist, somehow the populist perspective that they are assuming. And there are already some decisions issued by the Supreme Court of Justice of the nation that are in this sense. So I consider the Mexican case is really, really interesting to be analyzing in this panel. So thank you so much for contributing to this discussion with the Mexican perspective. So now we are going through the next presentation. The next presentation is now it's the turn of Francesco Alberto Santulli. Francesco is a PhD in legal studies at the University of Bologna in Italy, and his paper introduced a new element in this framework, in this institutional framework that we have already started to analyze, because this presentation is focused on the crisis of political parties as a phenomenon of constitutional degradation. And he puts a question, a very relevant and important, a huge question in the title of his presentation: what is to be done? So Francesco, the floor is yours for 10 minutes, and we expect from you an answer to this very first question.
Good morning, everyone. First of all, I would like to thank all the organizers. I'm very pleased to participate in this interesting meeting today. In my speech, I will move from the birth of political parties, then to their crisis, which could be seen as a phenomenon of constitutional degradation. And finally, I will try to show how a solution to this crisis could come from the electoral system. Of course, this has to be a short presentation, so further information will be contained in the written paper. The organic theory of intermediate powers and their relationship with centralized political power is exposed in the famous opus de l'Esprit des Lois. Intermediate powers to which Montesquieu referred were, above all, the nobility and the clergy, and they had to act as a balancing factor of the power of the king, whose political power would otherwise have escaped any kind of delimitation. Of course, a lot has changed since then, not only because these two subjects has lost or at least changed their social position, but mostly because it's with the 20th century and the birth of a multi-class state that a new entity enters the scene, the political party. At the basis of the 20th century, in fact, there's the idea of capturing the complexity of society through tools for the composition of pluralism. In society, many ideas, ideologies, classes, and social conditions coexist, and it's considered necessary to compose this complexity through containers capable of translating it into a mode of political participation. In other words, only the party can contain this complexity and diffuse its potentially explosive effects. Thus emerges the idea of a subject, the party, which is by definition a faction, and which can represent the most important tool for integrating the relationship between society and state. Since the end of the 90s of the last century, a period of our Republican history, which can be summed up in the expression Republic of Parties, is closing. That was a republic founded on parties with strong collective identities, stable territorial ramifications, and with a capillary presence throughout the national territory. The crisis and the end of the mass parties seemed the logical consequence of several events: the end of the Cold War and the progressive disintegration of the ideological opposition, the social disparities caused by the consumer society, the increase of population groups which are difficult to inscribe in the watertight compartments of traditional social classes. The causes of these changes are many and can be briefly listed here. First of all, the fall of the Berlin Wall and the end of the Soviet Union not only favored neoliberal policies, but also pushed the de-ideologization of parties, which, having lost their original perspectives, have also lost their identity. This process involved all parties and not just those close to the Soviet model. Secondly, the new technologies have determined the transition from the organization of the party based on congresses, members, sections, circles, into modes of participation that are only apparently open, but in reality are extremely self-referential and which don't translate into an instrument of connection between organization and its members, but only between the leader and his base, or rather his followers. Moreover, as a national factor, there is the institutional crisis that led to the loss of credibility and legitimacy of the political parties on which the material constitution of 1948 was based. Crisis that emerged in all its importance in the referendum of 1993, which led to the abandonment of the proportional electoral system. The crisis of parties as a phenomenon exacerbated by endogenous and exogenous factors, moreover both national and international, can be framed as a phenomenon of constitutional degradation, since this crisis does not stop at the party system, but more generally involves a crisis of politics, of representation, of the relationship between voters and elected representatives, and of the parliamentary form of government. Indeed, this crisis empties the physiological functioning of the institution that characterizes a representative democracy and determines a general sense of confusion and bewilderment among citizens. A solution to this crisis must necessarily, but not only, pass through the preparation of an electoral law that finally sanctions a transparent relationship between electors and elected representatives, to make the former more aware in the exercise of their rights, and the latter more responsible in the exercise of their functions. Let's consider the sentence number 1 of 2014, in which our Constitutional Court stated that it's necessary to allow the voter a margin of choice for their representatives and to avoid violating the logic of representation provided for in the Constitution. If we interpret these two formulations of the court, we could say that in order to guarantee effective representation, it's necessary to define an electoral system that is substantially proportional, to guarantee the representation of all minorities and allow the choice of individual candidates. A possibility, yet remembered from some constitutional law experts, could be represented by single-member constituencies in a proportional system, as in the election of the Senate until 1993, provided for by law number 29 of 1948. On the one hand, territorial pluralism will be guaranteed, not resorting to blocked lists, but multiplying the numbers of colleges, with a consequent greater connection between representative and represented. The choice of the elector will thus be clearly identified on two levels, the one of the party and the one of the person, and the party will emerge empowered. It's in fact necessary to adopt a simple system, and this could be a system with small single-member constituencies, as many as the seats assigned to the single region, with candidates linked together on the basis of belonging to the same political force, and with a direct assignment of the seat to those who obtain a suffrage greater than 65. For the remaining seats, that is almost the majority of them, there will be a division with proportional criteria based on the individual result reported by each candidate. In conclusion, there is a clear interdependence between the stability of the electoral system and the stability of the political system. Moreover, if it's undisputed that the electoral law is a constitutionally necessary law, we know well that it has not always resulted in a necessarily constitutional law. In fact, the product of the parties' response to their own crisis has been repeatedly criticized by the Constitutional Court. Obviously, it's on the values of the constitutionalism that we must continue to invest as a leading light. But as long as we continue to think of the electoral law only in terms of a technical way of translating votes into seats, we will not go far, because it's not only this, and it regards our constitutional democracy. Thank you very much for your attention.
Thank you so much, Francesco, for this presentation and for including another element in this panorama that we have, enriching a little more with each presentation. Actually, listening to all your presentation, I have already thought many questions that I'm waiting to share with you in the discussion of this panel. Now, let's go through the following presentation that will be done by Francesco Savera. Francesco is a lawyer and PhD candidate in public comparative and international law at the University of Rome, La Sapienza, and he will be presenting a paper titled Limited Powers or Adequate Powers, Considerations on the Relationship between Freedom and Authority in Modern Democracies, starting from the reflection of Adrian Vermeulen. Thank you so much, Francesco, for being here, for presenting this paper, and the floor is yours for 10 minutes.
Thank you very much. Thank you, everybody, and I'm very happy and honored of speaking in front of you this morning. I'll speak about a very interesting article, a short essay entitled On the Originalism, that appeared on the 31st of March 2020 in the prestigious magazine The Atlantic. An article signed by Adrian Vermeulen, that is professor of constitutional law at Harvard Law School. An article that sparked an interesting debate in the academic world, and not only in America, but also in Europe. The text concerns constitutional hermeneutics. Vermeulen tells us that a constitution can be interpreted according to the maximization of individual freedom, borrowing from the text and beyond the letter of the text principles and rights that can dynamically adapt to the evolution and change of society, so that the freedom and the individual, which must be safeguarded by the power of authority, corresponds to a singular and ugly personal space of realization. This approach involves an unbridled expansion of individual autonomy, which ends up being a disintegrating factor in society, because it is not intended to strengthen community ties, but to favor the development of the individual. In opposition to this declension, our author describes the affirmation in the United States of the originalist school. Originalism aims to contain the expansive model of individual freedom, limiting itself to an interpretation of the Constitution that refers to the meaning that the founding fathers who wrote it wanted to give it. Antonin Scalia, Justice of the Supreme Court and the main representative of this movement, of which Vermeulen himself was a close collaborator, often used the image of the empty battle. Constitution is not an empty battle that we can fill at will, but a text died, from which it is not possible to deduce principles and rights different from those which were intended for it. A model of resistance, therefore, which today seems to be the majority in US legal world. Yet Vermeulen takes a step further. According to him, both of these models play on the same progressive logic of freedom, one in favor, the other in friction. Originalism has exhausted this task of resistance It is obviously insufficient if you want to redefine a new and alternative approach to law and constitutional interpretation. According to Vermeulen, it is essential to definitively overcome the dialectic between freedom and authority. He argues for the need to develop a moral constitutionalism, that is a hermeneutic model that allows us to read in the ambiguities of the written constitution the substantial and objective moral principles of which the authority promotes. Roles, hierarchy, solidarity between groups and subsidiarity are the interpretative elements that can be deduced from the fundamental charter, understood as principle that must inspire the action of the authority, indeed more, of which it must be the guarantor. In this sense, the measure of public power is no longer constructed in the relationship with freedom of the individual, which cannot be overridden, but in function of those same goals of morality to be achieved, no longer limited powers, but adequate powers, since protect liberty is not an end in itself. This is the words of Vermeulen. Vermeulen fundamentally reshapes the system of modern constitutionalism, considering rights and freedoms not as trenches for the defense against the attacks of the state, but as tools of communitarian rather than personal realization. Building of a moral order which is not in continuous progressions and growth in functions of the singular realization is a given and collective element to be defended, to be guaranteed. This construction, certainly not unprecedented, demolishes the modern way of conceiving the relationship between power and individuals. It exalts the Constitution as an ordering force, but upstream as the guarantor of a community construction, and not downstream as the protector of individuals' freedoms. And these reflections, whether they can be shared or not, question us precisely at the moment when the health crisis we are experiencing seems to have exposed all the limits of a model of coexistence entirely built on the inhibition of any unitary request. Just a few days after the article was published, the Atlantic magazine featured two very critical stances against Vermeulen's writing. Bright tones of rejection came from the pen of Randy Barnett, an academic at Georgetown University. No less caustic is the comment by Garrett Epst, professor of constitutional law at the University of Baltimore, who speaks openly of authoritarianism. In some way, both criticisms are committed to underline the danger of inserting an element of value in the exercise of jurisdiction. The hermeneutic method must rely on a basic neutrality, which makes it acceptable and equidistant with respect to the demands that come from below, to the social impulses that law finds itself containing and stirring up. In a plural and relative reality, these forces are many and often in contrast with each other. Neutrality, understood as the creation of a specific procedure, legal interpretation and deduction, and considered free from any possible influence of extra-legal elements, becomes a force that harmonizes those elements. It is the secularization of law, the advancement of what in Europe is called legal nihilism, faced with this necessary neutrality of law. Abstraction, Natalino Irde would call it. Every moral element becomes out of place because it will force us to think of the method as an instrument and not as an end. In this, Vermeulen's position for the mentioned criticism becomes unacceptable. In the logic of neutrality, it does not matter whether one follows either the originalist theory or living law one. Both play on the same logical level because they are aimed respectively at weakening the request for rights or maximizing it in a perspective of progressive redefinition and adaptation to the needs of society to coexist. What criticism does not seem to grasp in the frantic attempt to label Vermeulen as one of the many isms is that he reasoned from a different and farther perspective, orientating the right to secularization both as an element of resistance and as an element of favor, raises a question in terms of social cohesion, a unitary demand. The artificial element is disintegrating by itself because it is devoted to emphasizing differences and not to bring out the elements of common belonging. Our author therefore wonders whether the creation of a public space that does not have aspirations for justice is sustainable, so that does not reflect a recognized fact of common pre-state and in some way pre-social understanding. In other words, echoing the words of Massimo Cacciari, one of his fundamental books a few years ago, it is possible today to give a life to a constitution This is the true constitutional degradation. A constitution in the sense of Verfassung. Verfassung presupposes an ethos, that is a shared extra juridical instance, transcendent or not, that generates the nomos, the norm in conformity with the justice of the gods in Greek terms. Without this background, the laws is transformed into mere sophismata, into simple causal comment. It will not be the worth Antigone's life. In some way, Vermeulen's position enters powerfully into the Greek question of modern constitutionalism. That is, nowadays, the difficulty of thinking about public space, not simply understood as a space of validity of a given normative system, but as an element of cohesion. There is no question of the effectiveness of the rule in a given space and in a given time, a decisive issue in a world in which the supranational legal space and even the telematic legal space are added to traditional state legal space. The problem in this case concerns the suitability of the right to be a social format, a purpose that inevitably contrasts with the pluralist demand of modern societies devoted to a physiological and progressive disintegration. The question is, ubi ius ibi quoque societas? The conclusion. The pandemic crisis has brought to the limited the friction between individual freedom and collective interest, so much so that some observers even got to talk about a greater effectiveness of containment of the virus by countries with authoritarian systems, underlining a difficulty of Western democracies in balance between these two extremes. Certainly an oversimplification. However, it would be noted that the application of COVID-19 containment measures has been more effective and generalized in states with greater internal cohesion. Italy, for example, has managed to apply very strict limitation on personal freedom through legal instruments that comply with the balancing principles present in its constitution, without particular forms of coercion, or in any case with a rather light system of sanction and trust to ordinary police forces, and certainly not to the military. Not a small effort, considering that those measures have affected millions of people at the same time. In some way, the strong community intentions and the not indifferent social cohesion network of Italy have legitimized a considerable squeeze on freedom of movement, according to a legal procedure well codified by the Constitution, Article 16. Even with some precaution running, having judged those measures as appropriate to the emergency situation. It's not coincidence that with the fading of the pandemic in the spring of 2021, the voices of politics and civil society have multiplied, asking for the rectification of those same measures. Here, this organic element, this instance of protection of individuals, not simply in a singularity, but extremely in the social formations to which it belongs, finds it more difficult to protect in a legal system that maximize the value of individuality. A discourse perhaps easier to understand for the whole Europe, but which is difficult to translate overseas. In substance, Vermeulen not only proposes a recovery of this dimension, but theorizes a renewed centrality. Public space can only be reconstructed around a system of guarantee of communities' instances, which are at the bottom of the creation of a nation's shared ethos, and which need constitutional tools that codify its prevalence, not the annulment of individuals' freedom, but an adequate balance between competing and not imposing instances. Far beyond the stance for or against our professor's theoretical construction, it can be said that he has highlighted, like few others, the Greek question of modern public science, that is difficult for the latter to emancipate itself from a process of secularization that disintegrates its funding element, the public space that is born with the polis and that represents the place and the signifier of the legal phenomenon and social and community relations, a space that disintegrates in the discarding of the chthonic element of law, the link with the earth that Carl Schmitt had identified as the extreme and only element of resistance in front of the advance of positive morality. Without the Ordnung, the Ordnung loses its ethical and moral key, and it is lost to mere raws of validity in neutrality and abstraction, which ever make vain any constitutional construction, which by itself is an ordering and cohesive force. Vermeulen offers us an element of awareness and a path even with all its limitations. There is enough to start a serious debate on this. Thank you very much. And sorry for my English.
Thank you so much, Francesco, and I hope that part of this important debate we are going to start in now in the debate session. We are going to take advantage of this. Thank you also for including this theoretical, philosophical, and moral perspective to this panel. And we are almost approaching the end of the presentation. We still have two presentations. Now it's Marco Antonio Simonelli's turn. Marco Antonio is a researcher fellow on constitutional democracy at the University of Barcelona, Spain, and he also holds a PhD in comparative public law of the University of Siena, if I'm not wrong, in collaboration with the University of Foggia. Thank you so much, Marco Antonio, for being here, and the floor is yours for 10 minutes.
Thank you, Irene. I would like to thank, before beginning as well, the organizer, in particular Valentina Carlino, for hosting us today and for making this very nice meeting and workshop possible. So the topic of my presentation is essentially the relationship between populism and media. In other words, how public media, public and private media as well, can perform the function of barriers, of obstacles to the spread and rise of populism, and the way around, how populism is affecting the independence and the freedom of media. As we all know, the role of media in contemporary democracy is definitely vital. Like, alongside political parties and the civil society, media are the main channel through which the opinions of the people is formed and transmitted. Freedom of media is essential to pluralism of opinions and idea, without which a society cannot be called democratic. If you want to use the word of European Court of Human Rights, media are purveyor of information and public watchdog. That is to say, they provide at the same time a platform for debating ideas and perform an essential function to hold the government accountable towards the population, towards the populace. This is why it is of utmost importance for democratic quality to guarantee the independence and neutrality of media vis-à-vis interferences from political authorities. Yet the picture in Europe and all around the world as regards the independence of media is not so bright. If, of course, all European constitutions, all democratic constitutions solemnly affirm the freedom of expression and the freedom of the press. But if we look at the most used index of democratic quality, for example, the one elaborated by Freedom House, we see that actually attacks on the freedom of press and the freedom of the media are becoming more and more common, not only in autocratic or populist ruled countries, but also in consolidated democracy. Looking at the last report from Freedom House of 2019, the freedom of the press is under threat in Austria, in Italy, in Spain, just to talk about European countries. Well, even though freedom of media is basically in contrast with political authorities all around the world, with the rise of populism, the orders of problem, the panorama had substantially changed. Why? Because populist leaders have been able to exploit media to communicate directly to the people, bypassing and delegitimizing parliaments, so that the accountability fora for a populist leader is no more the parliament, but rather the populace, the people, the true people, to use an expression that is dear to the populist leader. In political scholarship, we refer to this process as mediatization of politics, which means essentially a process in which all the political communication happens through the public and private medias. And it's there is a substantial unanimity that actually this process has been conducive to more and more populism, because the market-driven logic of media outlets, by giving visibility to highly controversial ideas and proposals, like the one of populist parties, had favored the emergence and the visibility of populist politics. But from the perspective of this workshop, that is the perspective of constitutional law, is much more interesting to consider this relationship between populism and media from another point of view, that is the point of view of what happens when populist parties actually reach the power. As we already said, for example, in the last 2019 Freedom House report, there is a strong correlation between an erosion of freedom of expression and a populist rule. And so it is interesting to go and look what are the strategies employed by populist rulers in order to attack media independence and to tame the media system. Of course, the main source of inspiration, the playbook, is offered by the usual suspect, Poland and Hungary in Europe. We can add Romania to this, Romania and most of the Central Eastern European countries. And if we look at these countries, we may see that the strategies employed by populist parties are essentially three. The first one is the transformation of the public broadcasting service, that is a common feature in the media system of all European states, in basically a propaganda organ of the ruling party. This is exactly what happened in Poland in 2015. As soon as the PIS took power in Poland, one of the first measures it enacted was a law that stripped away from the National Broadcasting Council, or maybe was, because now it does not hold any significant power, but it is a non-partisan independent authority for the regulation of media, regulated in the Polish Constitution in Article 213 of the Polish Constitution, and conferred the power to appoint the boards of the radio and television public broadcaster to the Minister of Treasury, basically making the public service directly depending on government. Another strategy, that is the second possible strategy, is basically to pack the media regulatory authorities. This strategy looks pretty much similar to the one employed by populist parties as regards the judiciary, as regards constitutional courts and the Supreme Courts especially. In Hungary, this happened by conferring basically all the appointing and staffing and finance matters to a single person, that is the president of the media authority. The president of the media authority, directly appointed with basically unfettered discretion by the prime minister of Hungary, for renewable 9-year terms that, of course, are not conducive to the independence of the appointed person. And basically, also in this case, albeit we do have an independent authority, a formally independent authority, this authority ends up being factually controlled by the government. Also, we have to add that in the case of Hungary, the decision of the president of the media authority are not amenable to judicial review for compliance with the constitution, but only for compatibility with media legislation. So the judicial scrutiny over its decision is substantially reduced. The last possible strategy I have identified during my research is one based on de facto economic sanctions. For instance, the Polish government recently, last January, proposed a bill increasing taxation on advertising revenues for independent media outlets. This law already received a widespread international criticism. In particular, the Commissioner for Human Rights, Dunja Mijatovic, affirmed that this law is threatening media pluralism by suffocating the revenues of independent media outlets. All this strategy can be easily adopted by populist majority, because if we accept some provisions on the freedom of the press, democratic constitutions do not discipline the status and role of media in our society, so that simply by means of ordinary legislation or even governmental decrees, the independence of media can be attacked and destroyed. So the question that remains open is how to protect, how to insulate media from the threats coming from a prolonged populist rule. And of course, the main source of inspiration in this case may come from the opinions and standards elaborated by the Venice Commission for Democracy Through Law. And what I have to say that my impression is that, as usual, the answer to populism is complexity that has to be reached by the involvement of a plurality of actors in all fundamental decisions. For instance, as regards media independence, the appointment of media regulatory authorities should be based on a model in which a plurality of actors participate. In particular, the Venice Commission strongly favors a model in which the media community and the telecommunication industry should be able to appoint or delegate representatives to the independent authorities. In any case, and I'm approaching the conclusion, the very truth is, when it comes to populism, that any institutional arrangement is doomed to succumb to a populist rule if it's not defended by the civil society and international community. And this is why I believe that also in this case it's necessary and just obvious to turn the attention to the European Union. European Union indeed has the tools to protect media independence, and it's time for the European Union, and in particular the European Commission, to step in to protect media independence. What is the legal basis for this action? Because as we know, when it comes to the judiciary, the Commission needed to be creative. The Commission, the Court of Justice, needed to be creative in order to find a legal basis to protect the independence of the judiciary. In the case of media, it wouldn't be so difficult to find this legal basis, because now Article 30 of the revised Audiovisual Directive that was amended in November 2018 now establishes an obligation for member states to designate a regulatory authority legally distinct from the government and functionally independent. So in my opinion, I believe that this constitutes a solid legal basis to launch infringement proceedings against member states not complying with these requirements. Now, the directive is pretty recent, and the first implementation report of the Commission will be out only in December 2022. So it's very difficult to have the infringement proceeding launched before this date. In any case, this May, the 6th of May of this year, 7 Eurodeputies already addressed the Commission by directing a couple of questions related to the Polish legislation increasing the taxes on advertising revenues, and asking the Commission what it intends to do to protect media independence in the member state. So I believe something is moving at the European Union level, and this is definitely necessary in order to restore media independence in populist ruled countries. I think I exhausted my time, and even I think I pretty much reached the conclusion. So I thank you for your attention, and I give you back the floor, Irene. Thank you.
Thank you so much, Marco Antonio. You too added a very important element in this context about freedom of expression, media freedom, and also thank you to all of you because you all respected the time limit, the 10-minute time limit. So you are making my job very easy. So thank you so much. Now we are going through, last but not least, the last presentation of this session before the debate. It will be presented by Giulia Vasino. Giulia Vasino is PhD candidate. I don't know if you have already finished your PhD in public, comparative, and international law at the University of Roma La Sapienza. And Giulia is presenting a paper on deconstructing and rebuilding procedural standards, new trends in the current stage of the Italian constitutional review of legislation. So we are going back to constitutional justice. Thank you so much, Giulia. The floor is yours for 10 minutes.
Thank you. Yes, I'm still a PhD candidate. Thank you to the chair and thank you to the organizing committee for the great opportunity. As you said, we talk about the new trends in the current stage of the Italian review of legislation. In recent times, the configuration of the judicial review of legislation has been providing of centralizing tendencies. The academic debate agrees on defining the current stage of the Italian constitutional justice in Italy as the phase characterized by self-empowerment and even activism of the court. The expression of this widely perceived innovative course are significant. In particular, sharp criticism has been provoked by the reconsideration of the rime obbligate standard, which has traditionally represented a procedural self-imposed limit to the court's creativity, and at the same time a shield for the discretionary power of the parliament. More precisely, its binding value has been mitigated in recent case law. For this reason, many commentators argue that the institutional balance underlying the relation between the court and the parliament has been profoundly reshaped. After many years in which the court had generally displayed a cautious self-restraint regarding issues of constitutionality that involved the parliament's political discretion, the jurisdictional organ has opted for questionable interventionism. According to this view, the traditional principle of separation of power will be jeopardized. However, I would argue that these alleged fractures in the institutional balances and in the procedural framework can be considered as more apparent than real. The court conduct seems to show the intention to reconsider the constitutive elements of its decision-making without renouncing a jurisdictional modus operandi. Besides, the Italian court is now part of a well-established transnational judiciary network, which has contributed to building a permanent and mutually enriching dialogue between different constitutional systems and judicial models. From this point of view, both the court's willingness to readjust its old procedural framework and the existing high degree of interaction between supranational and national jurisdictional organs makes it difficult to picture a dangerous and unbridled monologue of the court on fundamental right issues. On one hand, under an internal perspective, it should be said that ensuring effectiveness in the protection of individual rights, as well as avoiding judicial review-free zones, appears to represent the driving forces of this change. This activist decisional approach would reflect a renewed sensitivity of the court, as Marta Cartabia said. It is undeniable that the constituent elements of the constitutional procedural framework are indeed being called into question. However, the decisional options implemented by the court in the current phase seem to prove that the court's decision-making is firmly based on the intent to maintain solid procedural rules. Upon closer examination, new regularities emerge in the reasoning of the judgments in which the new jurisdictional technique takes shape. Indeed, the weakening of the rime obbligate criterion appears to occur precisely when the following conditions are fulfilled. First, crucially fundamental rights are at stake. Second one, a similar normative solution, albeit not univocal, can be used by the court as reconstructive reference provision to adopt an additive judgment, or in Italian, sentenza additiva. Previous dismissal decisions on the same matter containing a plea to the legislature to amend the statute can be identified. And most importantly, the judicial warning on deaf ears. These steps would disclose a specific intention to rebuild new procedural path. More precisely, if the legislature fails to heed the judicial stimuli within a reasonable period of time, the court will annul the act with a further decision. In this way, the court seems to establish an explicit link between the Parliament's evasion of one or more warnings and the consequential legitimacy of its less constrained declaration of unconstitutionality. Drawing upon previous warnings represent a crucial benchmark to legitimize the court interventionism, but at the same time, it can also be seen as the backbone of this new procedural scheme. On the other hand, under a more external and European perspective, as I've already highlighted, the constitutional reasoning is also affected by the long-established debate between courts. In recent times, thanks to this mutual influence, a shared plural sensitivity has been interiorized in the court's decision-making. In its context, solid interconnections between jurisdictional models would consist of an additional reassuring factor or element to reduce widespread concern about the alleged court collectivism. Behind such a perspective lies the theory that the court's reasoning represents a crucial instrument to ensure transparency in judicial review, to ensure the so-called transparency in rationale. A transparent constitutional reasoning is capable to have also an internal effect. A rational and solid judicial itinerary would have an impact on the jurisdictional organ itself, since it would act as binding precedent for future judgments. The court discretion itself would be self-limited. Starting from this assumption, it should be mentioned that an important standard arising from the multi-level system is represented by proportionality. Proportionality consists of an important principle in Western juridical culture, but more importantly, also represents a key argumentative test the constitutional judges have at their disposal to make decisions throughout a systematic evaluation process. Scholars use the definition structured analysis with regard to the proportionality test. The proportionality test has been, as many know, originally drawn up by the German Constitutional Court, but thanks to the wide reputation of the Bundesverfassungsgericht, it was thereafter incorporated into the international juridical culture. According to this European German model, to successfully accomplish the proportionality test, a 3- or 4-step verification on the legislator law must be carried out. Proportionality plays also an important role in the Italian Constitutional Court's reasoning. However, despite its influence, it is still implicitly mentioned and far from being in line with the level of sophistication proper of the European model. For that reason, with regard to the Italian model, the former president of the Italian court, Marta Cartabia, has claimed the existence of a destructured proportionality. First and foremost, uncertainty on terminological level is observed. The concepts of rationality, proportionality, reasonableness are often fungible in the Italian court's judicial reasoning. Nonetheless, it can be argued that every single phase of the proportionality test is employed by the court on a regular basis. And the balances of rights, which shares the same core features with the proportionality test in strict sense, the 4th phase of the test, has been included in the Italian Constitutional Court's toolkit. However, the European scheme has not been implemented so far. The analytically clearer framework provided by the proportionality test would imply that the court would be able to make well-founded judgments in a more transparent and accurate way, and as such, it will be able to ensure a more reliable and fair reasoning. Meanwhile, it should be mentioned that the court itself has been manifesting the intention to overcome the destructured approach to proportionality. Not surprisingly, with decision number 1 of 2014, which also represents the starting point of the current phase of the Italian constitutional justice, the different stages of the test have been spelled out by the court with more precision. To conclude, I would say that the Italian court's judicial reasoning has been dealing with significant changes nowadays. Under a more internal perspective, the court's activism shows how the Constitution's gatekeeper is willing to adopt more interventionist instruments in order to make the fundamental rights guarantee more effective. But even this more proactive style of reasoning is developed through consistent procedural schemes, in which legislative unresponsiveness plays a key role in recent times. On the other hand, under a more external and European perspective, it should be said that the propulsive and homogenizing trusts coming from supranational and European models may improve the fairness and the transparency of the constitutional reasoning. In particular, the utilization of the proportionality test, which represents the mainstay of the protection of constitutional protected rights, would have a significant part in this development. Both this internal and the external perspective appear to jointly meet a fertile ground in this phase of the constitutional justice, and this seems to be related to the renewed approach to the court to the incidental system's essence. The determining propulsive impact of the protection of subjective rights on the process of reshaping procedural standards is fundamental, and it has been observed. In this context, whereby the judicial review of legislation is increasingly more permeable to the powerful influence of factuality, also the proportionality test can flourish. Factuality, indeed, plays a pivotal role in the structure and in the nature of proportionality test. Thank you so much.
Thank you so much, Julia, for this presentation. Well, now we are finished with all the presentation for this panel. I first would like to ask to all the participants, also external participants, people or professors or colleagues that have not presented the paper in this session, if they want to make a question, to make a comment, to intervene, or not. If not, I have a comment and a question for. Actually, it's a general comment, trying a little bit to summarize the main points of the presentation, and a question for all the participants. And just feel free to answer or to participate if you want to. But I think that the comments, they are more general, and they they are I'll make the comment and you'll see. You all talk about institutional arrangements that can be used in order to protect liberal democracy. And you underlined that all these institutional arrangements, actually, they are considered, or they are a way to balance the power of executive power through, from one side, the judicial power, and from the other side, from parliaments. So from one side, we have the first presentation presented by Simon, that was on the appointment of judges, when and how to appoint judges. There were other presentation on this topic about high courts, about constitutional review of legislation, about the Mexican case and the relationship between judicial power, the Supreme Court of Justice of the nation, the president, especially in a context in which that I consider it's a populist context, even if in Mexico this is this expression, this qualification of the power is really rejected. It's not well accepted, and you all underlined the dangers that are behind these relationships, and how you also proposed remedies, ways to solve these problems. And then there were other parts of the presentation that were focusing on parliaments, on majorities and opposition, underlying their weakness of parliament, especially in the context of pandemic. And then some of you also underlined, made some reflections, made a few analyses on the role played by civil and political rights. For example, the Marco Antonio presentation, but also the Francesco one on political parties. So you touched, and your consideration in all your presentation were really focused on this institutional aspect from a formal point of view. But I think, and this wants to be a provocative idea actually, I think that there is a big accent in this panel, and not in your presentation, because you pick up a topic and you develop the topic, but when we talk about constitutional degradation and how think about institutional arrangement, we have to consider human rights. Why? Because one of the main problems that is super evident in all constitutional degradation contexts is the human rights degradation. And especially there is an aspect that I think it's really important that we have to take into mind, that is the gender perspectives. Also, we should think about how to include in this institutional arrangement minorities, because it's one of the most important aspects in constitutional degradation. But I think that the gender perspective is fundamental. And when we talk about the gender perspective, I don't want to enter into the very complicated discussion about gender identity and sexual orientation, and who can be considered as a woman and who cannot be considered as a woman. I don't want to enter in this discussion. But yes, I think that in all this thinking about institutional arrangement, we have to take into consideration that there is the gender perspective that should be taken into account. It's very clear, for example, in the Mexican case, we all know that if we cannot talk about liberal democracy if all the population is not included in that democracy. I completely understand, of course, that maybe we are more used to think about liberal democracy if in the constitution and in the constitutional reality the systems of checks and balances works well. So we are used to construct liberal democracy on this perspective, but there is a big absent also in this construction that it is a human rights paradigm. And somehow some of you have mentioned this topic about, for example, the freedom of speech, the freedom of media. If we don't have freedom of expression, if media are not free, we cannot talk about democracy. We cannot, unless we cannot talk about the liberal democracy. Actually, it's one of the elements that is taken into account about every index, every data, to identify and classify liberal democracy. But also we have to take into account other human rights, not only political rights, not only civil rights, not only first generation of human rights, but all human rights, especially the inclusion, the inclusiveness of minorities, of excluded categories of people like women, and in order to think more inclusive arrangement to protect liberal democracy. Because if we not, that's my opinion, of course, but I would like to listen to your opinion. If we don't include this perspective, this more inclusive perspective, we cannot we won't have real liberal democracy. I mean, the concept of liberal democracy that we have now, thanks to the constructions that the development since the 17th, 19th century, now it's a more inclusive, must be a more inclusive concept, including also the gender perspective or minority rights or human rights paradigm. We can choose the concept that we want to include in order to have a more inclusive liberal democracy. I repeat, this is my opinion, but it was just to have a kickoff comment to generate a little discussion.
Can I?
Yes, please.
Okay, so about the gender perspective, many times we think about the gender perspective as a problem of minority, but I would like to underline that it's not this kind of problem, because we are not a minority in the world, and so, but it is real. For example, maybe a problem of the institutional functioning, the constitutional degradation is linked with the so-called glass ceiling, the soffitto di cristallo phenomenon, because this phenomenon excludes the possibility to have a different view of the problems and a different point of view to solve this kind of problem. So of course it is important to think about it and to insert this aspect in this kind of debate about the constitutional degradation. It's just an observation, nothing.
So, yeah, thank you. Of course, we are not a minority. We are actually half of the population, and unluckily, we are often treated as minorities. The more correct way, it will be like most vulnerable groups,
Yeah.
included. The half of the population is women and all the other minorities.
And there is on this point another problem, that sometimes the gender problem is in addition to other minority problems, for example, Black women's.
The intersectionality, actually.
Yeah.
Okay, I don't know if somebody else wants to intervene.
Hello. Well, I wanted to share a little comment about this gender problem, because I have been living 5 years in Africa, so it's completely a different perspective. And I think an important point is not only male or female, but non-binary gender. That's really a minority, the non-binary people. And there in Africa, in these countries, some of these manifestation of gender feelings, non-binary, are considered as illegal. So I wanted to stress on the difference that we can find in all the liberal democracy, even if we talk about constitutional degradation for human rights, we are discussing about these problems that in other parts of the world, like in Africa, they are considered as crimes, offenses to public morale. So is it really a degradation for us to start now discussing about these problems? Or are we really a step over this? I wanted to know your opinion about that. Everyone's opinion.
I don't know if anybody else wants to intervene also after the provocative question made by Ilenia.
Sorry, I would like
Julia.
to say something about minority in general, not gender gap. I know it is a fundamental problem in our countries, but I would like to say something about the attempts to include the minority perspectives in the constitutional process. For example, the constitutional courts. When I talked about transparency in the constitutional procedure, I also meant the attempts of the court to open to the minority during the process, or to open to the public opinion in some different ways. For example, the tour of the members of the courts in the penalty institutions, which is an important fact that I think also in France judges do, is a way to open to the civil society, to the minority of civil society. But this is not related to the gender topic. I just would like to say that some attempts are underway. I know that other many solutions and other many interventions must be deployed, but I think that some positive facts should be highlighted. Thanks.
Thank you. I think that if you want, I can see only Italian names in this session, and now because I cannot see Simon anymore. So I think that if somebody wants to intervene also in Italian, it will be allowed to, because we are Italian, I think, or we all talk and speak Italian. So just feel free to intervene in the language you prefer. So it will be easier at least.
I would like to join, but as you prefer, in Italian or in English.
I mean, we are in a multilingual conference, so as you prefer, as you feel more comfortable.
Allora, passiamo all'italiano magari. No, molto interessante la questione che ha sollevato per quanto riguarda le minoranze. Io il mio piccolo contributo per quanto riguarda anche l'argomento della mia relazione, cioè la legge elettorale, la crisi dei partiti e la legge elettorale. Mi vengono in mente, quando si parla di minoranze, le bellissime parole del presidente della Repubblica Saragat, che diceva: la democrazia non è solamente una questione, un rapporto di maggioranze e minoranze, ma è un rapporto tra uomo e uomo. Se questi rapporti sono umani, la democrazia esiste; se non sono umani, quella che chiamano democrazia non sarà altro che invece la maschera di una nuova tirannide. E lo strumento attraverso il quale tutti, le minoranze, ma in generale tutti, hanno la possibilità di essere rappresentati, di far sentire la propria voce, è proprio la legge elettorale. E quindi è vero che quando si parla di legge elettorale può sembrare un argomento complesso, senz'altro, magari anche un po' noioso, però in realtà è proprio quello strumento che permette a tutte le minoranze di essere rappresentate. Cioè noi siamo davanti a una dicotomia da tempo, che è quella della rappresentanza, cioè di rappresentare o di governare. La legge elettorale serve a rappresentare o a governare, perché se serve a rappresentare, allora attraverso le elezioni vengono rese palesi quelle che sono i vari orientamenti politici esistenti in un certo momento nel paese. Se invece continuiamo a ripetere quel refrain, quel ritornello che le elezioni invece servono a sapere chi ci governa il giorno dopo le elezioni, allora evidentemente non vogliamo, evidentemente non, cioè, stiamo sbagliando, ecco, il significato da dare allo stesso atto elettorale. E allora forse in una situazione incerta come quella attuale, ricordare le parole di Carlo Lavagna in questo caso potrebbe aiutarci, cioè credere che la nostra Costituzione celi dentro di sé, nelle sue pieghe, un sistema elettorale proporzionale, perché solamente attraverso un sistema proporzionale che tutti e ovviamente anche le minoranze, soprattutto le minoranze, possono avere una rappresentanza, perché se il Parlamento, per dirla con Hegel, è il porticato che esiste tra la società civile e lo Stato, allora chi non è in Parlamento, chi non è rappresentato in Parlamento non esiste, non c'è. Quindi forse bisognerebbe ripartire dalla legge elettorale, ecco. Questo semplicemente.
Grazie. Peraltro tutto questo discorso sulla rappresentanza e sul tema dei partiti politici in America Latina si sta svolgendo appunto già nel senso di vedere dei meccanismi che in qualche modo possano includere le minoranze, ma a livello di quote. Quindi le quote per la comunità LGBT, le quote per ovviamente i popoli indigeni, la maggior parte insomma le ha già. C'è stata una recente sentenza del Tribunale elettorale di Aguascalientes, se non ricordo male, in Messico, che ha appunto concesso delle quote alla comunità LGBT, alle persone anziane, alle persone insomma, di una certa età e alle persone disabili. Quindi attraverso la giurisprudenza, non c'era una normativa in quel senso. Quindi mi pare che già insomma, si stia creando un po' questa apertura. Prima ho visto la mano di Giorgio Grasso che... Giorgio, per favore.
Buongiorno a tutti e grazie. No, devo dire grazie a tutti questi giovani che sono stati tutti molto, molto bravi. E tra l'altro io approfitto della circostanza di poter intervenire in italiano perché il mio inglese non è buono come quello di tutti, diciamo, i partecipanti. C'è un elemento comune che secondo me in tutti questi interventi forse si può identificare, no? Questa idea di questa constitutional degradation, no? Che comunque tiene unito il convegno. E allora io sono andato a vedermi un rapporto che consiglio a tutti voi di consultare. Sono i rapporti annuali che vengono fatti dal The Economist, il Democracy Index, no? Quello 2020. E se andate a leggerlo, quello riferito all'anno passato, proprio in relazione a quello che diceva Irene, cioè il problema dei diritti fondamentali, si registra, la causa è la pandemia, però si registra in tutte le regioni, le macro regioni, che sono prese in esame da questo rapporto, che poi come sapete fa un ranking, no? E quindi colloca i diversi paesi dentro diverse categorie, diciamo, dalle full democracy fino ad arrivare agli stati autoritari, ma anche negli stati, diciamo, cosiddetti pienamente democratici, c'è proprio una democratic regression, no? Che è molto, molto forte in tutti gli ambiti dove dovrebbe esserci invece una effettiva protezione dei diritti fondamentali. Quindi anche in quei sistemi, diciamo, di piena e consolidata democrazia, dal punto di vista dei diritti fondamentali vi è stato un passo indietro nel 2020. Quindi se c'è stato nei paesi pienamente democratici facile interrogarsi cosa può essere accaduto in quei paesi che invece già più faticosamente, no, riescono a stare, no, dentro etichette, no, di quasi democrazia, di transizione verso la democrazia, eccetera. E quindi questo mi pare un po' un elemento, quindi andatevelo a leggere perché è interessante, questo lo suggerisco a tutti questi giovani. Al giovane bolognese mi fa molto piacere che sia un proporzionalista, questo vuol dire che veramente il pluralismo, perché voglio dire la scuola bolognese è una scuola dove vengono fuori, diciamo, delle idee anche fortemente maggioritarie in campo di sistemi elettorali, ma questo vuol dire davvero che c'è il riconoscimento, diciamo, di tante idee diverse, no? È bello sentire da un giovane citare quelle idee che Carlo Lavagna aveva manifestato in quel saggio del 1953, no? E quindi quando ci fu poi l'approvazione di quella che allora veniva chiamata la legge truffa, mi ha fatto molto piacere che sia proprio un giovane di Bologna, come dire, a portare, quando gli amici e colleghi bolognesi hanno anche posizioni più, diciamo, più di maggioritario in senso stretto. Ecco. Grazie per l'occasione di essere intervenuto e bravi davvero a tutti, oltre che agli organizzatori, ma siete tutti giovani di grande livello. Bravi davvero.
Grazie Giorgio. Anche la professoressa Scotti voleva intervenire, non so se lei interverrà in italiano, in inglese o in turco. Mi lascio libertà di scelta anche per quanto riguarda l'uso della lingua.
Facciamo che mi allineo al nuovo trend e continuo in italiano. Innanzitutto grazie mille. Io purtroppo non sono riuscita a seguire tutta la sessione perché appunto essendo in Turchia ho avuto problemi di connessione e questo accade spesso quando io seguo delle conferenze, non so se è il caso o se sono altre ragioni, mettiamola così. In realtà no, scherzi a parte, volevo fare una domanda che si collega parzialmente a quello che diceva Irene sulla necessità di adottare una gender perspective e anche su quanto si diceva a proposito della legge elettorale e la necessità di considerare l'introduzione delle quote. Siccome mi sembra che anche ieri ci siamo interrogati molto su quali possono essere gli strumenti per evitare questa constitutional degradation, le quote vengono appunto spesso menzionate tra i sistemi per poter mantenere forme di controllo e di garanzia per le minoranze, per i cosiddetti gruppi deboli. Io però vivo e lavoro da tempo in un ordinamento dove le quote sono considerate come la peggiore delle possibili opzioni da introdurre a tutela delle minoranze, ed invece in Turchia è stato introdotto uno strumento che paradossalmente è stato introdotto anche in Svezia, che è quello della commissione parlamentare che si occupa specificatamente di garantire il gender mainstreaming in tutta la legislazione. Io ho condotto uno studio sul funzionamento di questa commissione in Turchia e ho scoperto che in realtà, nonostante tutto lo scenario di cui abbiamo più volte parlato, che anche i panelist di questa mattina hanno menzionato, la commissione funziona perché nel momento in cui è stata istituita si sono previsti dei meccanismi di partecipazione della società civile che sono ancora adesso attivi e che sono quelli attraverso cui la società civile si fa sentire nel momento della produzione delle norme. Io mi chiedevo se, appunto, ragionando di meccanismi istituzionali per preservare gli ordinamenti dalla constitutional degradation, voi avete incontrato istituzioni, meccanismi, mettiamola così, simili o assimilabili a quelli di queste commissioni parlamentari permanenti e specificamente istituite per la tutela di gruppi deboli o del gender mainstreaming. Non mi riferisco soltanto alla questione dei diritti delle donne, ma più in generale per la tutela dei diritti, perché a me sembra che nonostante i contesti siano sempre più corrotti dall'avanzata di forme di autoritarismo, questo tipo di meccanismi mantiene ancora qualche forma di funzionamento a beneficio della protezione della democrazia. e sono molto interessata a sapere voi cosa ne pensate. Grazie mille.
Non so se qualcuno voglia intervenire.
Magari per...
Io al massimo potrei intervenire con un'ulteriore domanda, cioè mi sorprende che in Turchia ci possa essere una commissione così e anzi mi rallegro del fatto, visto che invece la tendenza era verso una sorta di oscurantismo nei confronti delle donne. Ultimamente, diciamo, amici miei che vivono in Turchia mi hanno detto che sempre di più in giro si vedono donne che cominciano a ricoprirsi. Qualche anno fa si erano tolte il velo, adesso lo rimettono addirittura integrale, quindi si sta ravvivando questo sentimento religioso, per cui com'è compatibile questo con la situazione in Turchia?
Posso riprendere la parola? In realtà il ragionamento adesso è veramente un ragionamento molto lungo. La connessione tra i profili religiosi, la regressione costituzionale e l'atteggiamento delle donne è davvero un discorso molto lungo. Brevemente io posso dire che questa è la sensazione che viene spesso riportata in Occidente. Per quella che è la mia esperienza in Turchia, ci sono molte donne che si stanno rivelando. In Turchia però il velo integrale di solito non appartiene alla popolazione turca, è qualcosa che viene dalla migrazione, sono per lo più le donne siriane o le donne che comunque migrano da altri paesi più a oriente che prediligono il velo integrale, anche perché il velo integrale non è quello che viene neanche propagandato dalla maggioranza al potere. L'AKP è un partito di ispirazione religiosa, ma tende a proporsi come un partito di ispirazione religiosa moderata, e anche il tipo di velo che viene prediletto dalle donne dell'AKP e che viene considerato come l'espressione della modestia di una brava donna religiosa e rispettosa dei principi coranici secondo i dettami dell'AKP è quello che in Turchia si chiama il turban, cioè la fascia con il velo, non si vedono i capelli ma la faccia si vede completamente. Ed è anche interessante secondo me notare come le donne che si rivelano in conseguenza di un'adesione a questi dettami in realtà appartengono prevalentemente alla borghesia medio-alta che si è creata con l'ascesa al potere dell'AKP, ed infatti c'è una netta differenza tra il velo integrale prevalentemente nero o comunque scuro delle donne che insomma arrivano in Turchia a seguito dell'immigrazione, tra le donne che appartengono a famiglie che tradizionalmente si sono velate e quindi che non avevano abbandonato il velo neanche a seguito delle riforme secolariste, perché anche in quel caso il velo lascia scoperto la faccia ma è prevalentemente scuro, e le donne invece di questa medio-alta borghesia che si velano con costosissimi foulard, Gucci, Ferré, insomma è un'espressione di moda, non c'è niente, io spesso dico sono molto meno modeste loro di una donna che porta i capelli sciolti ed è secolare, perché poi c'è una particolare attenzione al trucco, alla cosmetica, quindi davvero il rivelarsi, nel senso di rimettere il velo, rivela un'adesione politica più che una vera adesione ai principi religiosi, mi verrebbe da dire. Quanto alla commissione, per tornare invece ai profili istituzionali, appartiene a quello che diceva ieri il professor Cabolu, c'è stata una prima fase di riforme e una seconda fase di regressione, la commissione appartiene alla fase delle riforme. Per il momento ancora non è stata abolita, sappiamo che tutto accade in un ben poco tempo, come è stato fatto con la Convenzione di Istanbul, si può cancellare tutto con un semplice decreto, però per il momento la commissione c'è e tra alti e bassi funziona. Mi sembra un meccanismo istituzionale interessante da studiare, proprio perché alla fine rimane nei gangli delle istituzioni e anche se ha un piccolo spazio magari serve a proteggere quei diritti umani di cui parlava Irene prima. Era questo l'elemento su cui mi interessava confrontarmi, però sì, anche la questione religiosa rimane importante.
Grazie Valentina, grazie anche a Ilenia per essere intervenuta in questo dibattito. Non so se avete altri commenti, altre domande, altrimenti sono già le 12:04. Sono le 12:04, 12:05, quindi possiamo anche considerare chiusa, finita la sessione. Io veramente vorrei ringraziare tutti i partecipanti, concordo con quanto diceva il professor Grasso, siete stati tutti veramente bravissimi, io ho imparato tantissime cose oggi, quindi grazie, grazie, complimenti. Ne approfitto anche per ringraziare gli altri colleghi che hanno partecipato e hanno assistito come pubblico alla sessione, e ringraziare ovviamente il Dipartimento di Studi Aziendali Giuridici dell'Università di Siena per l'organizzazione dell'evento, la professoressa, in particolare la professoressa Tania Groppi, e Valentina Carlino, che è quella che sta dietro le quinte, qui visibile però, per tutta la parte tecnica e logistica dell'evento.